And a very good evening to you, and welcome to today's edition of Politics 101, our Tuesday edition. I know it's been quite a weekend in some parts of the United States where a lot of you are. Bad weather. In Guyana, if you're joining us, welcome. The weather continues in Guyana to be up and down. But at least in Guyana, we don't have to deal with snow and all of that stuff. But of course, we have the rains, and we're accustomed to that at this time of the year. Welcome down to Politics 101, our edition this evening. Please, if you can. If you can share the link and let others know that Politics 101 is on the air tonight. We're going to be talking about issues in the news, but from a legal standpoint. We've been talking a lot about the amendment to the National Resource Fund, the Natural Resource Fund. As you know, the coalition passed that law 2 years ago, and the PPP moved to amend the law during the Christmas season. In fact, they did, using their majority in Parliament. And many people have made the pronouncement that it is tantamount to stealing the access to our patrimony, the monies that have been accrued thus far from oil and gas, which are sitting in a bank in New York, and the previous law passed by the coalition. Many people are saying that it was a far superior law to the one that the PPP has introduced via an amendment. Lots of talk about the political motives of the PPP. But we want to talk tonight about the legal implications. As you know, we've been talking a lot about the rule of law and the fact that the PPP is governing without due regard for the rule of law. People have been asking, are there legal implications for the way in which they have amended that Natural Resource Fund law? Can they be taken to court? There are lots of arguments. Some lawyers seem to suggest that there was no violation of any fundamental constitutional rights, so there is not much to review there legally. Others have argued that it's a violation of Article 13 of the Constitution, which provides for inclusion in the governance of the country, and that something like the Natural Resource Fund falls in to one of the most important aspects of governance in modern Guyana, in contemporary Guyana. And so therefore there may be grounds there to challenge what the PPP has done. Others have talked about the fact that the actual mace was removed And when the law was passed, the mace was not there, and parliamentarians were not in their seat as they took their vote, and that is grounds for ensuring that the law is null and void. So we're going to try to get answers to those questions tonight, and other related questions from one of the lawyers that was involved in litigation on behalf of the coalition during the 5 months impasse. I'm talking about Mayo Robertson, who is a Guyanese-born lawyer, spent a lot of his time in Washington, D.C., but has returned home and is a practicing attorney and the one who has had tremendous experience. And as I said, contributed to the litigation during the 5 months he was part of the legal team that argued on behalf of the coalition. So here we are. Welcome to tonight's edition of Politics 101. We're going to be talking about the legal implications of the Natural Resource Fund Amendment by the PPP. So let's get going and welcome Attorney Mayo Robertson. Mayo, good evening.
Good evening, David. It's good to see you.
Same here, and Happy New Year.
Thanks, and same to you and your family.
Yes, it's been a long time since we talked. I know you were very much part of the team last year, and we have the 2 petitions before the court. Are you involved in those petition cases?
Yes, I'm involved in particular in petition 99. I'm involved to some extent in both of them, but more especially in petition 99.
Remind our audience which one is 99.
Petition 99 was the one that was filed based on detailed irregularities in the election. We did not get to air the grounds of the petition. We did not get to explore or for the public to see what we believed was a tremendous departure from proper accepted norms of conducting an election, because the Chief Justice had ruled that the petition could not go forward because she was not satisfied that President Granger at the time was served within the 5 days required by the law for service of the petition. And she had further ruled that he was a necessary party. And since he was a necessary party, the petition could not go forward because he was not served.
Yes, go ahead.
And we filed an appeal to against the Chief Justice's order. And in response to that appeal, the respondents, mainly the PPP and the Attorney General's office, they filed a preliminary application to have the appeal dismissed on the ground that the Court of Appeal did not have jurisdiction to hear it. And there was a ruling about 2 or 3 weeks ago where the Court of Appeal, in a majority opinion, ruled that it did have jurisdiction to entertain an appeal of petition 99. Just the government and the PPP had asked the court for 10 days to decide whether they were going to appeal to the CCJ. And just this afternoon, I received a notice of an application on behalf of the PPP and the government for leave to apply, for leave to appeal to the CCJ. So I guess that's where we're going to go with petition 99.
So they are going to appeal. They are going to appeal that decision, yeah.
I actually received that notice this afternoon.
Just
Notice
this
of
afternoon. So as they
yes,
would say in the journalistic world, it's breaking news.
yes, yes, yes.
Yes, so you've heard it here in Politics 101 that the PPP will appeal the decision of the Court of Appeal. May I remind our audience what were the grounds on which the majority of the Court of Appeal ruled that it did have jurisdiction to hear the appeal of that matter?
Well, there was a question about whether an appeal should have been taken to the full court, which is an intermediate appellate court between the High Court and the Court of Appeal, or whether the appeal should have gone directly to the Court of Appeal. Eventually, the court concluded on a reading of the Court of Appeal Act that it was proper for the appeal to be brought in the Court of Appeal and not in the full court. The government at one stage had taken the position that there is no appeal at all that is allowable from an election petition, which was slightly different from the position that was taken by the PPP. But eventually, both sides, well, not both sides, but both the government and the PPP made the argument that the appeal should have been to the full court and not the Court of Appeal.
Yeah, that was it. And there was the well, you said originally it was the PPP that argued that you can't appeal any decision on an electoral matter from the High Court, right?
Correct. That's essentially what it was. Yes.
Right, but they departed from that eventually.
Yes, for the most part, they relied on the argument that the appeal should have been to the Court of Appeal and not to the full court.
To the Court of Appeal. No. So they were
Sorry,
trying to get away through a technicality there again.
The full court, yes, to the full court, not the Court of Appeal. Yes.
Not the Court of Appeal. So they were
Yes.
trying for another technicality there.
I guess so. I mean, we obviously want the petition to be aired. We want people to be able to see what transpired. And it would be, I believe, in everybody's best interest if the public were to know. I think it would even serve the government's best interest. Then they can say, well, you know, we were legitimately elected. The court has heard all the claims for irregularities, and the court has made a decision that there was no credible evidence. That will do them good. But the Guyanese public at large, I think, would be satisfied if they were to be able to examine, along with the lawyers, all the claims for irregularities and have them either proven or disproven. But lawyers being lawyers, it's not surprising that they're making many efforts to have the matter killed before it even gets aired.
Before it gets, I want to ask you two questions, Mio. One is, you're of course a lawyer, and I think I've known you for a little while, and by temperament, you're a very measured person when it comes to answering questions. But I still ask you, what do you think is the political motive of the people not wanting these petitions to go forward?
Okay. And David, you're right. I'm a lawyer, not much of a politician.
I know.
Generally, when a person takes the position very strongly that they don't want the public to hear certain allegations, it is because the allegations tend not to put them in a very good light. You know, there's a presumption in law called spoliation of evidence. For instance, if somebody has control of evidence and before the trial takes place, they destroy it, the courts, especially in the United States, would tell the jury that they're entitled to assume the documents that were destroyed or the evidence that were destroyed were going to be against the interest of the person destroying them. So I don't know what their motives are, but I think as a general principle, people who don't want issues to be aired are people who believe they would stand to be embarrassed or exposed for impropriety if those issues are aired.
Well, that's as far as much as you're going to get from Mayor Robertson. That is a strong statement because, as Mayor said, he doesn't get involved in the political side of things. Not that he doesn't have a political view, but lawyers are careful, especially when a case is ongoing. You want to be very careful about what you said. What about the other petition? You said that you are only partially involved in that one. Remind us what that one is about and where it is right now.
Petition 88 deals specifically with narrow legal issues. They're not going to be in that petition a lot of evidentiary issues about whether people voted who were not eligible to vote. The question is going, or the questions are going to center around whether or not the regulation under which the recount was held was valid. It's going to deal with whether a particular section of the law that gave the commission, the election commission, the right to amend the Representation of the People Act, whether that is constitutional. So there were very narrow legal issues. Whether the order that allowed for the recount was a valid order, and then whether the legislation that allows the Elections Commission to amend electoral laws is constitutional. That matter was aired more fully before the High Court, the Honorable Madam Chief Justice, and she ruled against the petitioners, and the petitioners being, of course, representatives of the APNO AFC coalition. So that matter has been appealed. The substantive matter has been appealed to the Court of Appeal. We never got in Petition 99, we never got to the substance of the appeal. It was stopped on a procedural basis in the High Court. And then when we took it to the Court of Appeal, the application was made to stop it on a procedural basis again. But in the case of 99, there was actually an airing of the petition. Legal arguments were made. The Chief Justice came down on the side against the coalition. And it is that decision that is now being appealed to the Court of Appeal.
To the Court of Appeal.
Yes.
Mayor, when immediately after the election was awarded to the PPP, and many people were asking for a speedy trial of these matters because we have a history in Guyana where petitions are sometimes not heard in a cycle in 5 years. And we got off to a very quick start, but there seems to have been a lull or a slowing down of the process in the last 6 months or so. Am I correct in making that observation?
Well, things have moved a little more slowly than anticipated, but we did get a hearing on Petition 88 in the High Court. So that moved quickly. And we're now in the Court of Appeal. And I suspect that very shortly there are going to be case management orders where the court would outline the timeline for submissions to be presented and for arguments to be made. So I believe, at least in the case of Petition 88, there's a very good chance that it could be heard before the end of 2022, certainly. In the case of 99, I think it could take a little longer because if we are successful in the CCJ, and I strongly believe we will be, then the matter, the appeal would have to be heard substantively by the Court of Appeal. And if we prevail there, it'll have to be sent back to the High Court for the petition to be proved. So that is going to take a much longer time, and we had always anticipated that. 88 we thought would move a little more quickly, and in fact it is, because the arguments were heard and ruled on in the High
Court. And Mayor, you were part of that initial case that challenged the constitutionality of the recount order. Remind me the name of that case. It was.
Well, we had filed 3 cases. There was Ulita Moore.
Ulita Moore. That's the one I'm trying to remember. Yes.
That was the first case, and in that case we had argued that the agreement between President Granger and then opposition leader Barra Jagdeo to have a recount supervised by CARICOM was unconstitutional. And the Court of Appeal agreed with us. And once that case was filed, the CARICOM team departed. But then there was a further agreement to have a recount done by a different team where GCOM would still have control. And that is the recount that eventually led to the PPP being placed in power.
Yeah, and of course that recount had 2 components, the raw count and then an audited count, right? So I suppose a lot of those issues would come up in 88, right?
In 88, correct.
In 88. Yeah. Before we move off these cases, there was the outrageous attack on the Court of Appeal, the 2 judges who formed the majority by members of the government. Mayor, in all of your years of practice in the United States of America, I know, and you may have practiced other places, and in Guyana, have you ever witnessed that where members of another branch of government led into a co-equal branch in that manner?
It is pretty remarkable that a government minister would specifically attack members of the judiciary on a decision in an ongoing case. It is pretty strange. And you know, perhaps there's a little bit of a parallel when there was a ruling against former U.S. President Donald Trump, and he was accusing these judges of being Democratic judges, and John Roberts, Republican appointed Chief Justice, pretty much chided him publicly, saying, there's no Democratic judge and there's no Republican judge. There are no Bush judges and Obama judges. They are simply judges trying their level best to render fair decisions in difficult circumstances. And that's the exact thing here. We have judges who try their level best. These are difficult issues. These are difficult issues, and tensions are high on both sides. And it is rather unseemly for a public official, especially at the level of minister, to publicly attack judges just because they render a decision with which he does not agree. It does not bode well. Does not bode well for the rule of law and separation of powers in this country.
Exactly. The rule of law and separation of powers. We have tried on these shows because tempers run high. Understandably, a lot of supporters of the opposition are on shows like these. They tend to be uncomfortable with decisions made by the Chief Justice, for example, when she would have ruled more times against their side than the other side. And we have tried on this show to say, you can criticize a ruling, but you have to have respect for the institutions. That Absolutely. We are new societies, and we are trying to build institutions and build confidence in these institutions. And we want institutions like the courts to outpass executives. Executives come and go, but they come and go ahead. You wanted to come in there.
Yeah, and David, I agree with you 100%. institution building is especially important for new democracies such as ours. I mean, we're probably about 55 years post-independence, and that is pretty young for a country. And one of the things that can create chaos and division in any society is when we begin to destroy the institutions that were put in place to serve us well. And sometimes they rule in our favor, sometimes they rule against us. And that's just the way life is. I have disagreed with many judges over the years, but I would never publicly impugn the integrity of a judge, or I would never publicly attribute to a judge any motive other than the desire to honestly come to a decision based on difficult and hotly contested circumstances.
Mayor, there was a judge, I think it's Ramdani, who recently said that it's very difficult to get a fair case, a political case in a place like Guyana, given our ethnic environment. Where you stand on that comment made by him?
I don't know Mr. Ramdani. He's a lawyer. I don't think he's a judge.
Lawyer, I meant lawyer, sorry. Yes.
He's a Guyanese practicing somewhere in the region. It's unfortunate because what it does is that it fans the flames of the basest instincts in our society. People who believe that everything we do is done because of some type of racial animus. And if we have a senior practitioner, senior counsel, making a public statement that it is impossible to get a fair trial because of ethnic issues in this country, I think it is extremely unfortunate. I think it's extremely unfortunate because you're essentially telling people, well, you know what, if you ever have a case against the government, you may as well pack it up unless you are of one ethnicity. And that does not make sense. That undermines confidence in our judiciary and one of the fundamental pillars of our democracy.
Yeah, it was indeed an unfortunate statement. Yes, you're just joining us, Politics 101, this evening. I have Attorney at Law Mayor Robertson, who has been integrally involved with cases brought by the coalition during the 5 months impasse, and he has continued to be involved, as he has said, in the petitions that are before the court, the elections petitions. And he has been refreshing our memory. People of my generation, male generation, the word refresher course was very much part of our upbringing. You know, you need a refresher course every now and again. Perhaps it's one of the reasons that our scholars and lawyers and other practitioners lasted so long and were always on the ball even when they were advanced in age, because they would have done a lot of refresher courses. But we'll be doing some refreshing here this evening, walking us through some of those cases. Mayor, let's turn our attention to the Natural Resource Fund and the implications of what happened 2 weeks ago when the PPP used this majority in Parliament to amend the law in a real drastic way. Let me ask you the first question right away. There was the commotion in Parliament. The parliamentarians on the opposition side expressed their disgust, and the mace was removed from the speaker's desk, and a replacement mace apparently was put there, and a vote was taken, allegedly, but some sections of the opposition have been arguing that the law is null and void because the fact that the mace wasn't there really meant that an important procedure was breached. Where you stand on that?
David, that's a difficult one because it comes back to the question of separation of powers. Parliament has the right to set its own procedures. And for the most part, the courts will not look over the shoulders of Parliament, would not second guess the Speaker if he makes a ruling one way or the other. So the Speaker decided that the vote was properly put, that the vote was properly carried. He ruled that whatever it was that happened with the mace, there was a mace in place. And I think the courts would be extremely reluctant to review that and look into Parliament and say, well, you know, Mr. Speaker, you can decide that, because that essentially is his domain. If the Speaker makes a ruling, we may or may not agree with it. But my sense is that the courts are not likely to review, or if they do review, they're not likely to reverse any ruling made by the Speaker on procedural issues in Parliament. I think you would have to show that the Speaker did something blatantly unconstitutional, like, I guess, call people who were not elected to Parliament and put them to sit there, and that type of thing that blatantly violates the Constitution, the courts will review. But as far as the internal workings of Parliament are concerned, it is my sense and my feeling that the courts are not likely to do anything about that.
And I tend to share your view. Am I correct in thinking that what we probably are risking here is conflating rules and laws, in the sense that each branch, especially the legislative branch, can make its own rules?
Exactly.
Right. Expand a little bit on that. What you may call it, introduction to law, if there is such a course. 101. What's the difference between a rule and a law?
Well, a law is passed by the National Assembly and assented to by the President, and has the power to govern the lives of all Guyanese generally. Now, whereas a rule can be made for a particular branch of government, telling them how certain things need to be done within that branch. It certainly would have applicability and validity within the confines of that branch, but it would not necessarily be of general application to the public at large. I guess that's the neatest way I could think of describing it.
Yes, and of course, that law can be made so long as it does not violate the Constitution, so long as the rule does not violate the Constitution.
Exactly.
That's the critical matter. Let me go on to this. Yes. Let's go on to the second question. A lot of people, especially on the opposition side, have been saying that there should be a review of the amended law. But before we get to you answering that question, let me ask you whether the law that was passed by the coalition when it was in office, and it was passed after the no confidence vote, does that invalidate the law?
No, not at all. There is nothing that says legislation enacted after the no confidence vote was unlawful. There was a government that was there, a government that was not put out of office by a vote. And you may remember during the litigation concerning the no confidence motion, the CCJ had been invited to say that the government must get out of office and they must hold elections by a certain date. And the CCJ said essentially, no, we can't do that. You know, we can say what the law is, and we will then expect the parties to govern themselves accordingly. And there was never any pronouncement by the CCJ or any other court that could be remotely interpreted as saying any legislation passed by the government after the no confidence motion was not validly passed. Because
Mayor, let me pin you down on that, yeah? Go ahead. No, go ahead. Finish. Sorry.
in any event, even if we were to assume that the no confidence motion was validly passed in December of 2019, there is at least a 90-day period that is required for a new election to be held. And if I remember correctly, that first bill was assented to in January of 2019.
Yes.
Certainly within that 90-day window. But even apart from that, I still don't believe that any valid argument can be made that laws passed by Parliament after the no confidence motion are not enforceable.
Yeah, and let me do a follow-up question here, because there were limitations on what was called an interim government as far as spending is concerned. For example, I want to ask you, in the case of the passage of laws, are they held the same standard as an interim government spending, or is legislation, if you will, is legislation held at a higher standard, even for an interim government?
My sense is any legislation that is properly enacted by a majority of Parliament and assented to by the President becomes law.
Becomes law.
Exactly.
Yeah.
Now, until a court declares that the law is unconstitutional or not valid for some other reason. The CCJ did suggest that the government should act as if it's an interim caretaker type of government. And they didn't spell out specifically what that entailed.
Right.
I think the government at the time interpreted it to mean that they should not undertake any significant measures that would change fundamentally our laws or our constitution during that time.
Exactly.
But the country has to be governed. No court would suggest that because a no confidence motion is passed, everybody should just say pens down, you do nothing, and just wait for the result of the elections. That is preposterous, and I don't think anybody who is a reasonable lawyer, a reasonable person, would suggest that the government cannot, in the interim, enact laws.
From a legal standpoint, Neil, how effective was the original law passed? Was it in the tradition of similar laws in other oil producing countries? The original law passed by the coalition.
Right. No, the original law passed by the coalition is similar in structure and intent. The whole idea behind these sovereign wealth funds, David, is to recognize that any revenue generated from an extractive industry does not belong only to the generation that was involved in extracting the whatever it is from our territory. It belongs to all Guyanese for now and in the future. So we should not give to this present generation the right to spend the money any way they see fit. And that's the thinking that pervades these sovereign funds all across the globe. The one I think that is probably the best known is the Norwegian fund. And
right.
Their fund, I believe, was established in the 90s, I think. And there have been several changes in government since then. There have been right-wing governments, there have been left governments, there have been centrist governments. But because there has been a fundamental consensus on the necessity for the fund and on the necessity for having safeguards to the funds being depleted, there have not been any significant changes to the legislation involving the Norwegian sovereign fund. Now, in some of the weaker democracies and more authoritarian countries, there are sovereign funds in place, but the safeguards are not there. I mean, Equatorial Guinea comes to mind, for instance. They have a sovereign fund, but Equatorial Guinea is a notoriously authoritarian country, so that the restrictions on withdrawals from the fund were not enough to prevent those who wanted to rule the country the way they saw fit from tampering with the revenues generated by the extraction of oil. And in fact, I think Equatorial Guinea has now reached the point where their oil production has plateaued and is going to begin to decline. And it's really unfair because those resources are the patrimony of the people of Equatorial Guinea. And for one generation to use those funds willy-nilly is just not fair. So the original bill, the original act rather, Act number 12 of 2019, was designed to make it not easy to spend these funds. In particular, there was a management committee of, I think, of more than 22 people, I believe.
22, yes.
Yeah. And the methods of withdrawal and the way the withdrawals were calculated, some people thought they were overly complex, but I think the complexity reflects the desirability to make it difficult to deplete these funds. The legislation did not make it impossible to use the funds for development. It just required certain standards to be met. It just required a very high standard of review before the funds were used. So I believe the old legislation worked. I believe it perhaps could have been tweaked around the edges here and there, but I don't believe there needed to be the type of fundamental sweeping changes that we saw in the more recent legislation.
And those fundamental sweeping changes, some people are arguing, warrant a review of the law. Where do you stand on that? Because some lawyers are saying it's really difficult to get a court to review such a case because the amended law, the amended act, does not violate any fundamental constitutional right. Others are arguing that it conflicts with Article 13. Where do you stand in that?
I think a colorable argument could be made that there is a constitutional issue here, because Parliament does have the authority to make laws, but the laws have to be made for the good governance of society. And it will not be a straightforward claim, it will not be a slam dunk, but I believe a colorable argument could be made that this certainly does not lead to good governance. As I said, giving away the natural resources of the country is almost like agreeing to give away a part of the country, because once we exploit those resources, they're non-renewable. They don't come back. And Guyana was created not just for this generation of those of us who happen to be here in this part of the 21st century, but it was for all Guyanese now and for those to come. And just as how the government would not willy-nilly make a deal with Venezuela to say, you know what, let's settle this dispute, let's give you half of the equipment. Because the country belongs to all of us. And our natural resources are no different. And we have been fairly successful as a country in Guyana in having a united front when it comes to the border issues with Venezuela. And that is because there has been a high degree of consultation, and no government since independence has tried to go it alone, and no opposition, more importantly, has tried to say, we're going to side with Venezuela. There has always been an attempt to reach across the aisle to discuss this matter because they realize that Guyana belongs to all of us, not just the governing party. And I think the same approach needs to be taken with our natural resources. Natural resources are part of Guyana. And if we are going to use them, then they must be used in a way for which there is the broadest consensus of support. So consultation is extremely important at every step of this process. Yes, eventually, I imagine there will be a majority vote, and in a lot of circumstances, majority vote might go along with what the government of the day wishes. However, the opportunity to discuss and to educate the public would allow the public an opportunity to give some feedback and may influence the way the final bill is put before the parliament for a vote. So, you know, I would make the argument that to have a fund that allows the revenues from our natural resources to be spent so easily and so completely in one generation violates the principle that laws should only be made for the good governance of the society. It is, as I said, it's not a slam dunk.
Right.
I believe a colorable argument could be made. I would invite constitutional scholars to research it because I think it's something that should be looked into. But more importantly, I think it's important for the government and successive governments when it comes to dealing with our national patrimony to involve the public in discussions as much as possible. I have a problem with the new legislation, for instance, that allows the government to spend 100% of income generated from oil in the previous year up to $500 million. And then for the second $500 million, up to 75%. I believe we have sitting in the bank in New York something about around $500 or $600 million from last year. So the new law would essentially allow them to pretty much wipe that fund out. The first 500 million, 100% could be spent. And then for the next 500 million, that small amount of 500 million, 75% to be spent. I think we should not be in an unholy haste to spend money that is not ours.
That is not ours.
It is unfair.
Yes. Yeah. Have you had a chance? Go ahead. You're done?
Yeah, I'm done, Dave.
Yeah, Mayor, have you had a chance to look thoroughly at the local content law that was passed on the same day?
Not thoroughly. No, not thoroughly. I have a sense, but I haven't looked at it thoroughly, I have to admit.
Any preliminary observations from a cursory look?
Again, it would seem that we are not putting in place enough safeguards to make sure that Guyanese get the maximum benefit of what this industry has to offer. We cannot make the assumption that we don't have the talent. We cannot make the assumption that we don't have the resources. And I think the current law, again, from a cursory look, does not give enough, does not put enough weight on the talent that Guyanese have to operate the oil industry. We have to make sure that we don't continue to handicap ourselves. Clearly, there's some areas in which we don't have expertise, but we can legislatively handicap ourselves from participating across the board in the industry.
Yes, and certainly we shouldn't do that. You are tuned to Politics 101. My guest this evening is Attorney at Law Mayo Robertson, and we have been talking about the law and society, the law and politics, looking at some of the developments in the last couple of weeks from a legal standpoint. What are there possible constitutional infractions, for example, as far as the amended Natural Resource Fund, and Mayo has been grappling with that. We refreshed ourselves on elections petitions, that are before the courts. Mayo, something has been worrying me, and I want you to weigh in on this. It's been months now since Orrin Boston was murdered in the wee hours of the morning, and the police opted for internal investigation, and they promised that they would have a speedy investigation. It's been almost 6 months now, no movement. First of all, are you surprised? And second, what could be done?
Well, I'm not surprised. I don't know that much could be done other than for the public to continue to express its outrage at these types of things. There has been a reluctance historically for us to prosecute police for crimes, especially crimes of murder. I happen to be involved in another case where somebody was killed under very suspicious circumstances while in police custody. And
that's the East Bank case.
Exactly.
Yes.
Exactly.
Remind us, Peter Headley case?
Yes.
Yes, go ahead.
And that case too, the DPP has indicated that there is not enough evidence at this point for her to make a decision whether charges should be brought, but a coroner's inquest is going to be held. And I guess then the coroner's jury to recommend whether or not anyone or no one should be held criminally responsible. We have to get over this culture of being reluctant to prosecute police officers when they do wrong. It is difficult to understand how that killing could have been justified. You go into the man's house, he's pretty much sleeping in his bedroom. It is very difficult. And it should not take that long to have a proper investigation. But I understand that the complaint authority and the DPP want to be as thorough as possible, but these things must be given high priority. That is my opinion. It must be given very high priority because it's important for us to have confidence in our police. And if the public believes that the police can somehow literally get away with murder, it does not bode well for police-public relations. And it's, as I said, I'm not surprised, but I think it is unfortunate that it's taking this long.
It's surprised that it's taken long. And of course, those are two matters, but there are other matters. We still have the Henry Boys matter that is still unresolved.
Yes.
You know, Mayo, when things like these happen, explain to our audience how it affects the stability of the nation.
Okay. Well, as you were saying earlier, David, it's important that we nurture our institutions, which are important pillars of our society. We have to have respect for our judiciary. We should have respect for law enforcement. Because if the public perceives that somehow the police can do what they want and whenever they want with impunity, it is going to be impossible for the police to get the public's cooperation in solving crime. And anyone with the most rudimentary understanding of policing will tell you, if the police don't get the cooperation of the public, it is almost impossible to be effective in crime fighting. And what that does then, people would tend more and more to want to take the law into their own hands. Because now we have a law enforcement that we don't trust. And when that institution breaks down, we're not going to go to the police, we're going to deal with it. So it is very dangerous to create a situation where confidence in our law enforcement is shaken. And they must know that law enforcement is held to a very high standard. And we should not let the acts of the few miscreants tarnish the reputation and affect so fundamentally one of the most important pillars of our society.
A couple of comments here on the program, on the comment section. This is a very informative production. One other comment here, very intelligent, Mr. Robertson. Another commenter, I do agree with you, Guyanese need to stand together when it comes to managing our resources. Yes, sir, because who are involved should be exposed. You know, I was saying this morning, Leo, you and I we're country boys. You're West Police.
Yes.
Belgium,
El Dorado, Belgium.
Yeah. El Dorado, Belgium, yes, like Boston French. And I was making the point that sometimes we who have been quote unquote educated at poor people's expense, sometimes forget the intellect that resides in the ranks of ordinary people. Not just their own intellect, but their capacity to spot what old men individuals call superior argument. You know, and I'm amazed sometimes on these programs, the extent to which we think something like law is complex. But to ordinary people, it's not really complex because they may not be academically trained like us, but they're certainly intellectually sound. Have you experienced that as you move around the country?
Oh yeah. It is a phenomenon that I have noticed not only here in Guyana, but particularly in Guyana. Folks who don't have a lot of formal education, you'll be talking to them about stuff, and they will cut right to the chase. They would say, but this is not right because so and so and so and so. And they will let you know how things impact them on a personal level, in a way that we don't always appreciate as we intellectualize. So you make an absolutely valid point. And in a sense, I found it interesting as I did jury trials, especially in the US. You make your arguments before the jury and you think of all the best ways you can to try to persuade the jury. And the end of it, whether the jury rules in your favor or not, sometimes the things that you thought were not important at all, those are the things they would hang on to and say, but no, we know this person could not have done that because so and so and so and so, and that is the type of intuitive intelligence that is very present here in Guyana too. And I find it a lot in the countryside, but also in other parts of Guyana.
In other parts of the country, years ago, decades ago, I went to my first class, sociology class, at the University of the District of Columbia, which you know very well.
Right.
And, the professor, this is what, 40 odd years ago, the professor is asking, where are you from? So I said, from Guyana. He said, Guyana. He said, that's the place you go to the market and you hear men quoting Shakespeare at will.
Yep.
They have a bag of mango on their back. And they're quoting Shakespeare and Keats. And he said he visited Guyana once, and that is what he took away. Ordinary people being very proficient in the literature.
And it brings us back. It brings us back to what I was saying earlier, David. We have to assume that members of the public understand what's going on. We should listen to them when we're going to pass important legislation like this. Members of the public understand how it impacts them, how it impacts their children, their children's children. So we should not rush things through. What harm could be done by having an extended comment period, getting the public involved? We don't have a monopoly on intelligence and good judgment just because we get elected to Parliament. And we have to change this attitude and appreciate what you're saying, David, that the people out there are intuitively very, very intelligent and have a sense of what is good for them.
Exactly.
And to me, rushing legislation through suggests that we don't have respect for the intelligence of the Guyanese public at large.
Intelligence of Guyanese public. Mayor, I was asked by Mr. Coffey, who is a regular on this show and other shows. I was on another show this morning, and he said he noted that I have Mr. Robertson on, and he wanted me to ask you a particular question, part of which you answered before. He's making the link between reparations and the Sovereign Wealth Fund. And he wants to know whether he is on solid ground, in the sense that the reparations movement is linked in some way to the Sovereign Wealth Fund, and so that any law surrounds that has to take into consideration the different experiences of slavery and indentureship and colonialism as a whole, as we try to decide how to equitably divide that fund. Would you care to answer him?
Well, I think a plausible link to debate. We speak in our national anthem about our ancestors who shed their blood, and this soil so they hallowed, and from them are we. And we have to recognize that the Guyana we enjoy today was built on the blood, sweat, and also many tears of those who came before us. Those who were brought here involuntarily were made to sweat and toil. And even if we say, well, oil is not directly connected to that, but it was their sweat, it was their blood that created this society. And the fact that they put all of that into the ground means that we owe them a debt from whatever we're able to recover from the ground. So I would support a connection between our natural resource revenues and reparation.
Mr. Coffey, I hope I represented your question well, and I hope that the answer given by Mr. Robertson meets your approval. It certainly meets my approval, because as soon as we began to talk about this natural resource fund, I argued that we have to have a historical aspect to it. It's not just economics. It's about history, and I think Mayo puts it very well. Our blood was shed into that ground, in that earth. And what comes out of there bears the scars of bondage. And we have a big chance now to correct those economic scars, at least. If we correct the economic scars, we may deal with some of the psychological scars. We have a chance, if the money and the revenues are equitably distributed, that we can eradicate poverty, which is perhaps the biggest hangover from slavery and colonialism and indentureship. And so therefore, Mayo, I really appreciate that perspective that you brought up. And thanks, Mr. Coffey, for raising that question and forcing us to deal with it and to answer it. Mayo, you've been practicing in the courts of Guyana since you've come back. How are you faring? Any big adjustment you have from practicing all those years in the States and now practicing in Guyana?
I think the one thing where I feel the biggest difference is the pre-trial process, the discovery process. You know, in practicing in the US, you routinely exchange documents. You send out requests for things to the other side that they know they have to comply with. We have some of those rules here in Guyana, especially since the institution of our new rules of civil procedure. I think it was in 2017. But I don't believe the profession has come along there yet. And people still fight you, and you have to go to court to get orders, to get documents. And I find the litigants in Guyana, by and large, want to have their day in court. So a very high number of the cases that you file, you end up having to litigate. In the US, if I filed 100 cases, I might have tried 5. Yeah, if you file 100 cases, you're going to probably try about 80 or 90 because people have not yet bought into, in a big way, the idea of trying to resolve these things, trying to mediate, trying to go into arbitration. They like to have their day in court. That is a big adjustment. I mean, it clogs the system too, and it explains to a certain degree why we take so long to get matters heard.
One commentator says Mr. Robertson is quite diverse in his training, obviously. He's not just a criminal lawyer like most lawyers. He seems to have a grasp of the issues. Mayo, we're in this new era of oil and gas. What advice would you give to young people who are getting into the legal profession?
And I say this knowing that it is said very, very frequently, but the biggest opportunity you have when you get into the legal profession is an opportunity to serve. And you should not take that lightly. On your shoulders rests the responsibility to make sure that Guyana continues to be a society of laws and not a society of men, that there is respect for the rule of law, there's respect for the rights of women, there's respect for the minorities, and above everything there is respect for our soil and our climate. Young lawyers have to pay a lot more attention to the implications of climate change and why it should matter to us. You know, we live in a country where most of our coastline is below sea level. And we have seen the tremendous amount of rainfall that we have had out of season, I would say, here in Guyana. So I would urge young lawyers to look at issues involving climate change. Look at issues involving the abuse and misuse of our resources. And most of all, be committed to serve the people of Guyana. And, you know, yeah, money is important, but if you serve people well, the money will come. The money will come. You know, to quote Fenton Ramsey Hoy, who taught us in my first year of law school. He said, you work for the masses, you get paid every day. So
there you go. There you go. The late Fenton Ramsay, former Attorney General of Guyana in the 1960s. Joe is saying here, I am only hoping that Mr. James Bond is listening to Mr. Roberts' opinion and views tonight. Well, I won't take you there, but to see what we were just talking about, people make linkages as they do here. Neil says history must be remembered when thinking about the Natural Resource Fund. And yes, reparation justice for African Guyanese must be on the table as we negotiate these funds. Jillian, from your part of our part of one of our parts of the world, Washington, D.C., Maryland area, is Mr. Robertson willing to become one of the legal scholars of the PNCR? I will put that one to you. Jillian is from Maryland, D.C. area. So I put that to you.
I am willing to help and I'm willing to serve. I wouldn't impose myself on any political party.
I suppose Julian is making reference to the back and forth that is going on now within the PNC on those matters. I won't take you there, Mayo. But I think that is what Jillian means here when she asks if you can speak for from Mayor Robinson, I wish the same. But never in the recent history of Guyana we have had an installed regime. Things are not normal, and they, the PPP, are certainly not acting in a democratic way. When a regime, because I think Jaiwan raises a very important thing there. When one side respects or try as much as possible to respect the rule of law, and the other side blatantly disregards the rule of law, what does that set up in the society? Should we then lose confidence in rule of law and come down to the level of those who disrespect the rule of law? How do we keep our people grounded in the notion of justice and the rule of law in an environment where you have a government that is clearly out of order and not concerned with basic norms in society?
Perhaps because of my grounding in the law, I would urge people always to respect the rule of law. And don't let people make you into something that you know you should not be. And we can learn lessons from the civil rights movement in the US. We went to courthouses decades after decades and got turned back. The police would slaughter us and brutalize us, and we'd go to court and we got nothing. But we didn't stop, because that's all we have. I mean, other than opting for anarchy, which is not an option, we have to try to make sure the institutions that are in place are strong and they work for us. So we have to keep on going to those institutions, and we have to keep on making sure that the institutions eventually understand that we have rights to be protected by those institutions. So I would say, let us keep on knocking at the door. Who would have expected that Chauvin would have been convicted for killing George Floyd? 20 years ago, as recently as 20 years ago, that would have been unthinkable. But we didn't stop. We kept on going, and I think we need to do the same thing. Anytime we find ourselves in a situation where we believe that we are observing the rule of law, but perhaps the other side is not.
Mm-hmm. And as we come down to program time, Mayor, I will give you some parting words. In a couple of days, we'll be observing the birth anniversary of Martin Luther King Jr. I think he would have been 93 years if he were still alive. You are from that generation of civil rights. You might have been a student at that time, but you are from that generation of civil rights workers, civil rights lawyers. As we remember Dr. Martin Luther King Jr., what would you like to say to Guyanese as we observe that anniversary?
Well, a couple of things. One, we must be more doers and less talkers. It's very easy for us to sit in our armchairs and criticize and say this is wrong or that is wrong, but we have to be prepared to do something about it. And it's not always comfortable when we decide to do something about it. Yes, we may have to endure a little bit of pushback. We may have to endure the discomfort of harassment by the police from time to time, but we cannot sit supinely by when norms are being rejected, when institutions are being threatened, and just keep a safe distance and talk. Because if Martin Luther King was only a talker, and he was a wonderful talker, but he was willing to do. He marched, he got beaten, he was locked up. And if we're willing to do those things, then they will not ignore our words. If we're mere talkers and not doers, they will easily ignore our words.
And what an apt message on the eve of Martin Luther King's birth anniversary. We in Guyana and the rest of the English-speaking Caribbean and the Caribbean in general, we have walked the walk. Our history is littered with doing. Our history is littered with doing. And it is quite an opportune message. Mayor, I want to thank you for coming on to the program and for enriching the tradition of this program, which is committed to a kind of discourse that is aimed at informing people, aimed at mobilizing people, aimed at educating people, but above all, aimed at sharing of information. And I think that you have brought that tonight. Thank you very much, my brother. And I shall be calling on you more often than I've done in recent times. So thank you very much. Thank you very much, Mayor. Mayor Robertson, attorney at law, who's being integrally involved with the cases on behalf of the opposition, coming on this eve of Martin Luther King's birth anniversary and enriching our conversation and holding aloft the banner of Guyanese and Caribbean tradition of informed discourse. I want to thank all of you, all of you. Raquel says here, Sir Mayor Robertson, thank you. And you are a wonderful talker too. Beautiful voice, I must say. Oh, Raquel, beautiful voice. And thank you all. That was our vote of thanks tonight there from Raquel. We from Boston call her Rocky. And Rocky loved the voice. Right. Thank you all for staying with us this evening and tomorrow. We're going to be tackling the news of the day, the Norton Harmon saga. We thought Norton's election meant that we had settled all the problems, but apparently they've not all been settled. And now we have a standoff between the Norton faction and the Harmon faction over whether Mr. Norton should be in Parliament as leader of the opposition and should assume the role of representative of the list. Tomorrow, big show. Henry Jeffrey, resident political scientist. Adam Harris, veteran journalist and politician too. Adam is a journalist, but he's a political man too. And Sister Adriana Thomas, who we have not had for a long time, passionate young lady, who has already made her intention clear that she's running for president at the next election. But they will be on tomorrow evening to deal with the big issue of the day. Should Aubrey Norton go to Parliament and become opposition leader and take over as representative of the coalition list? Tomorrow night, join us. Big show. Until then, tata, tata, as we would say in Guyana.
Please help keep Politics 101 on social media and broadcast television. If you are in North America, please donate via Cash App or PayPal.
If you are in Guyana and the Caribbean and don't have access to Cash App and PayPal, email your pledge to dhines6106@aol.com and we will direct you how to get your donation to us. Thank you in advance for your donation.